Bom dia a todos, meu nome é Leonardo Nemer Caldeira Brant, eu presido o Centro de Direito Internacional com sede em Belo Horizonte. É com muita alegria que eu saúdo a todos os presentes, saúdo igualmente os professores internacionais e nacionais que irão estar conosco durante essas 2 semanas, durante o 16º curso de Direito Internacional. Eu gostaria de dizer que, em primeiro lugar, esse curso foi todo desenhado num novo modelo online. Nós já estamos aí no 16º curso desse gênero. Ele foi totalmente adaptado às novas circunstâncias, o que, de certa forma, permitiu também uma extensão do número de participantes, de professores internacionais e nacionais participantes. Temos este ano 19 grandes nomes do direito internacional que estarão presentes conosco durante essas 2 semanas. Num primeiro momento, portanto, eu gostaria de agradecer a todos os professores que colaboraram conosco, que estarão conosco nesse período, com palestras muito interessantes sobre temas dos mais variados do direito internacional. A todos eles, o meu muito obrigado. Em segundo lugar, saúdo e agradeço também aos alunos, aos estudantes que estão participando neste período de julho, conosco durante essas 2 semanas. O nosso também muito obrigado. Esse é um curso que envolve uma grande equipe do Centro de Direito Internacional, a qual eu tenho o imenso orgulho de colaborar e de presidir. Ele é um curso que pretende trazer para o Brasil e para a nossa América Latina o mesmo modelo de cursos que, de forma quase centenária, já é uma tradição nos países europeus e nas principais universidades do mundo. Portanto, para nós uma grande satisfação que tenhamos ele já há mais de uma década no Brasil. O curso de inverno de Direito Internacional, com toda a sua abrangência e extensão, não seria possível de ser realizado igualmente se não fosse a relevante parceria e a confiança e o apoio da Fundação Konrad Adenauer no Brasil. A ela estendo um caloroso agradecimento e tenho a certeza de que estamos contribuindo juntos para os valores do direito internacional, para os valores dos direitos humanos, para os valores do Estado Democrático de Direito, para os valores da democracia e, com certeza, para a compreensão e construção de um mundo, de um universo internacional mais justo e mais equilibrado. Portanto, agradeço de forma calorosa ao apoio da Fundação Konrad Adenauer no Brasil. Gostaria, portanto, de dar início ao 16º curso de inverno de Direito Internacional, esperando que todos tenhamos 2 semanas de muitas atividades e aprendizado. Um forte abraço a todos.
Hello everyone, we are here today again to continue our lecture with Professor Jean Thouvenin. But first I would like to thank again Cedin to allow me to be here today with you as a moderator. So to make easier for us to follow up the explanation, I would like to make I did a very brief list of main points approached in the last Wednesday when Professor Thouvenin presented to us the main aspects of international sanctions, okay? Such as the terminology, the distinction between sanctions and measures, which sanctions are lawful and unlawful, types of sanctions, those implemented by the United Nations and those implemented by the states. I also point here further sanctions implemented for a group of states and those implemented unilaterally. And he also explained to us those domestic sanctions. Professor Thouvenin gave us some examples, but now I prefer to give the floor to Professor. Please, Professor Thouvenin, it's a very pleasure to me to be here again with you. So take the floor or the screen as you prefer, and let's move on.
Thank you very much. First of all, it's my pleasure again. And I'm happy to go on the discussion we began 2 days ago, and I was very interested by the questions put by the students, very smart questions. And perhaps before going further, I would like to come back on one point which is probably crucial or a point of interest for everyone, and on which I think we answered perhaps a bit quickly. The question is, what if a UN sanction is itself unlawful? Whether it is contrary to a general international law, contrary to the UN Charter, perhaps, or contrary to perhaps treaty law. Now, the fact is that, and this is the good point with this question, we have elements to answer. The fact is that the United Nations has been highly criticized in the 90s, and I said that last day, highly criticized in the 90s because the sanctions it used to adopt were hitting the people, the innocent people, rather than the wrongdoers. Mm-hmm. And it went very far, in fact, in the case of Iraq, but also in the case of ex-Yugoslavia. And perhaps you will remind that, I talked about Iraq last day, but you will remind that in the case of ex-Yugoslavia, there has been a very harsh civil war. And during this civil war, there has been what we call the Seat of Sarajevo. And during the Seat of Sarajevo, the UN had implemented not a sanction, but it was like a sanction because it was an embargo on the arms. But the decision of the UN was to prohibit any trade of arms with the people there in and around Sarajevo. But the result of that is that the Muslims of Sarajevo could not find any arm to defend themselves against the Serbs, which were provided with arms by the Serbs, by Serbia. And so the situation was very, very bad for them. And one of the reasons was the embargo. It went so far that one judge ad hoc, in a case before the court, the ex-Yugoslavia case led to, situation led to certain cases brought before the court, international court. And in these cases, there was a judge ad hoc, Lauterbach, and he said that the UN decision, the UN embargo, could perhaps be considered a crime against humanity as such in itself. So that went very far because of the consequence of that. Those people could not defend themselves against huge weapons that were shelling bombs on them in Sarajevo. So the UN has been highly criticized because of its sanctions regime and because it was not consistent with humanitarian law and perhaps more generally with the common sense. And this is why in the 90s, the UN tried to change. So it tried to reform itself. So this is the first answer to bring. What if the UN does not respect the law? Well, make it change. Provide critique to the UN. The civil society is heard at the UN and sometimes have success. And in this case, it is mainly the civil society, with, the international organization, the non-governmental organization, which criticized the UN and obtained the shift from the huge sanctions to the so-called smart sanctions. So that was in the 90s. And at this time, at this point, well, observers were thinking that's a progress. The UN is going in the right direction. But this new approach created new problems because a smart sanction is, by way of a definition, directed against a person, whether it's a head of state, it's a minister, it's a military, it's a person supporting a cause which is said to be unlawful. For example, the taking of Crimea. And so the smart sanctions are focusing on persons, and persons have rights. And then the question is, how are smart sanctions compatible with human rights, with the human rights of these people? And this is exactly here that the Caddy case I talked about 2 days ago emerged. And so again, the UN was very much criticized by outside, but this time not by the civil society. It was criticized by the European Union judge through the Caddy judgment, because the Caddy judgment of the European Court of Justice was very, very critical against the Security Council, saying that the decision of the Security Council was not respecting the basic of human rights, which is the right of defense. And there is another case that perhaps you know, which is very much like the Caddy case, which is from the European Court of Justice, namely the NADA case, NADA, which is a decision of the European Court of Human Rights. And the European Court of Human Rights also has a lot of influence, when it comes to human rights. And so because of these critics from outside, the UN again reformed itself by creating near to the Council, the Security Council, the ombudsperson, which is a referee, someone to refer to when you are on the blacklist of the UN Security Council, to claim that it's not you, that there has been a mistake, that you should not be on the blacklist. So that's the situation now. Is it sufficient? Is it satisfactory? Is it providing all the answers and guaranteeing that the UN Security Council will not violate the law in the future? Of course, no. And now we know how to do if there is a problem. We know that the local judges, so I talked about the European Court of Justice, I talked about the European Court of Human Rights, the local justice of states or group of states or regional organizations could oppose to the application, to the implementation of the UN sanctions. And if they oppose by stating that the sanction would violate the law, well, they bring a very harsh critic to the Security Council, which will change its behavior in the future if it wants to stay effective in its decisions. So I think that's what I wanted to bring to the discussion with respect to the UN Security Council's decisions that could perhaps sometimes violate international law. There are some solutions, even if one solution is not readily available, which is the seizure of the International Court of Justice. So for the moment, you know that the International Court of Justice can be seized for an advisory opinion by the Security Council. Well, we cannot really see the Security Council asking to the court, did I violate the law? That would be a bit bizarre. The General Assembly will not ask an advisory opinion to the court with respect to the legality of a Security Council decision. It cannot happen, probably legally speaking because of Article 12 of the UN Charter, but also because between these organs there is a sharing of tasks, and one cannot see the General Assembly asking such a question to the court, which would show that there is a discrepancy between the two organs, which would be, leading to the death of the UN. It cannot work like that. Now, you could have a situation where, in a contentious case, the question of the legality of a UN decision could be put. That's not impossible, and we know that there has been a case already before the International Court of Justice in which the legality of the decision of the Council have been put. It has not been dealt with because the dispute has been settled differently, but the question has been put. It was in the Lockerbie case. It's a famous case. And in this case, the Security Council, activated by the United States and Great Britain, decided to order the surrender of alleged terrorists to their justice, to the justice of the United States and of the Great Britain. And it was argued by Libya that the Security Council decision was running against, was unlawful because contrary to a treaty, the Montreal Treaty, regarding hijacking and air terrorism. And so the question of the legality, consistency, if you prefer, of the UN decision vis-à-vis the Montreal Convention has been put. So it was not to be sorry, yeah, the Lockerbie case.
The Lockerbie case.
Lockerbie case, yes. So, so that's not impossible that one day a question will be put to the court and that the court will have to answer whether or not a decision of the Council is consistent with international. But for the moment, we didn't see such an hypothesis brought before the court. Now, that was a precision I wanted to bring. Another precision I wanted to bring is about the very interesting question put regarding, I already answered, but I wanted to be clear regarding the decision of the United States to promise sanctions to judges of the ICC if they go in a certain direction, if they engage in a certain behavior. And so my answer is twofold on that. First, it's not good. It's a disgrace. Promising to sanction judges because they do their job is something really disgraceful. And to my view, it's politically unacceptable. Now, the second answer is about its lawfulness. Is it lawful or not? And then you have to look at that through two lenses, the lenses of international law and the lenses of the United States law, the domestic law. When it comes to international law, well, to assess whether it is lawful or not, you have to find the rules that could be infringed by this decision of the US. What rules could be infringed? And this is where I say, I don't know, I don't see what rules could be infringed in this case. Well, first of all, the treaty on the basis of which the judges act, well, it's the Rome Convention creating the ICC, but the United States is not a party to this convention. So that is very difficult to oppose to the United States what this convention says about what is the mandate and the job of these judges. So in my view, we will find very hardly something here. The second idea that could be envisaged turns around the notion of immunity. And so, you know that there is, in general international law, and the United States is supposed to respect general international law, if not the Rome Treaty. In general international law, there is this rule about the immunity of certain persons. So now, the question is, are judges of the ICC enjoying immunity in the United States? And here, the current answer is probably no. The current answer is no, because the judges at the ICC are not, I would say, are not fulfilling a traditional function in international law, contrary to a head of state, a minister of foreign affairs, an ambassador, all people that do enjoy immunity in the foreign territories. Now, a judge at the ICC is a brand new creation. So it would be very hard to find a customary international rules based on long-standing practice and opinion juris guaranteeing to this sort of person an immunity. Now, perhaps we could take a look at what is the immunity of members of agents of international organizations. And this is true that there is a rule regarding privileges and immunities of the agents of the international organizations. And the judges of the ICC are agents of an international organizations, because as you know, the ICC is an international organization as such. Now, but here again, the immunity of the agents, the functional immunity of the agents of international organization is based generally whether on a treaty, so there is a treaty on privilege on immunities of the agents of the United Nations, for example. There are rules about the immunity of the judges of the ICC in the Rome Treaty, or it can be based also on domestic law, because it is possible for a state to say, me as a state, I will grant immunity to other persons because I consider it is necessary. You can find, and I think it does exist, some national laws recognizing immunity to agents of non-governmental organizations. That happens. And this is something which is growing nowadays, because nowadays non-governmental organizations are in the fashion. The states now they have a tendency when they need an organization to create a non-governmental organization, like an association of under the Swiss law, rather than a real brand classical international organization. And this creates sort of a need of a new regime for the agents of this organization. And this regime is provided by the national laws of the states willing to provide this new regime. Well, if we look at the United States, we will not find any national law or practice of the judges recognizing immunity to agents of international organizations not recognized by the United States. So for the moment, I'm afraid I don't see the rules to oppose to the United States in their endeavor to sanction judges of the ICC if they go in a certain direction. That doesn't mean that it's good. It's politically insane, but legally speaking, I don't know the way. So that were the further point I wanted to develop a little bit after the very interesting questions put last time. So let's come back to my global flow of what I wanted to present. And indeed, the articulation I wanted to address is based on three IDs. You understood that. There is the first ID, which is that you will find unilateral measures implementing United Nations sanctions. There is no real question about that. And we said that's okay to the extent that a unilateral measure applies a UN sanction. There is a sort of immunity with respect to international law of these unilateral measures because they are covered by the UN Charter. Indeed, as we said, states are obliged to implement the UN sanctions under Article 25 of the Charter, and Article 103 of the same Charter says that there is a primacy of the obligations deriving from the Charter, including the obligations decided by the Security Council and the other international obligations. So normally, a unilateral measure implementing a UN sanction should be immune from any critique with respect to international law. Of course, this assumes that the UN sanction itself is compatible with international, but we saw this problem before. I will not come back on this point now. Now, a point I did not address 2 days ago is a bit tricky, and you know, it's the more interesting points, the tricky points. And the tricky point is the following. What if the UN Security Council adopts a decision in which it calls upon states to adopt certain measures. So the assumption here is that we talk about a UN decision which does not oblige states, which does not say states have to adopt certain measures, but the Security Council calls upon states to do something. So that's not an obligation, that's a call. That's a sort of recommendation. That's an authorization. Now, here, the difference is that there is no obligation. So you cannot rely on Article 103. You know, Article 103 of the Charter says, if you respect an obligation under the Charter, you cannot be deemed in violation of another obligation. Well, it works only in case of you respect an obligation. Here, the hypothesis I address is where there is no obligation, but there is a calling. There is a sort of authorization given by the Council to adopt certain measures. So, are we covered here? Is there an immunity with respect to international law as if there was an obligation? Now, there is a part of the doctrine which says yes. And they say, and it's rather convincing, they say that, look, when it comes to the recourse to force, when it comes to a decision adopted under Chapter 7 to have recourse to force, the UN Security Council calls upon states. It calls upon states. It doesn't order states to act, to use force, because some states will not, and some states cannot, but it calls upon states to adopt forcible measures. And everybody agrees that when states follow this recommendation, follow this call, they don't violate international law. So that tends to mean that when the Security Council calls upon states to do something, it has the same legal effect as when the UN Security Council orders states to do something. So that's an argument. Now, does it work in the case of non-forcible measures, in the case of economic sanctions, for example, right? Does it work? And the question is important because there is a case, at least one I know, which is Resolution 1929. Resolution 1929 contains articles deciding that states have to do something. And there is an article of Resolution 1929 which calls upon states to go further, to do other things. And so the question is, what is the legal regime of what states do under this call? Is it the same as the legal regime of what they do under what the Council decides? So this is not a merely theoretical question. So what is the answer? So, well, we've seen the argument of those who say that when it comes to forcible measures, it doesn't make a difference if the Council calls upon or decides. My view is that it doesn't work when it comes to economic measures. And the reason is that in case of use of force, well, the Security Council just cannot use force itself. The Security Council has no force, it has no army. And it can only call upon states to do things, to implement its decisions. When it comes to economic sanctions, there is no limit. I mean, the Security Council can decide anything it wants. And there is Article 41 and 42, which leaves him a large margin of decision in this regard. So that means that the Council could rather decide than calling upon when it comes to economic measures. It can decide. So if the Council does not decide, but call upon states, that makes a difference. That must make a difference. And so my analysis here is that when a state member of the UN implement measures that are not compulsory, but that are just suggested by the Security Council, there is no immunity under Article 103 of the Charter, and then the measure will be assessed as to its legality independently from the United Nations decision. So that's a bit tricky, but that's I think that's an interesting point. And it calls us also to take a very clear look at how the resolutions are drafted. That's very important to look at how it is drafted, whether there is an order, compulsory, or a mere authorization. And the legal consequences are not the same. Now, let's turn to the unilateral measures that I would call préter UN sanctions. So that means that the unilateral measures that go beyond UN sanctions and more precisely that are adopted without relying on a decision of the UN. So here we have a situation where there is no authorization. There is nothing special in the resolution calling states to go further than what the Security Council says, and then the states go further anyway. So what is the legal assessment of these measures? As I said last time, and I wanted to develop that a little bit more, as I said, a measure which is going further what a UN decision says is a little bit easier to defend as to its legality than a measure which is fully autonomous. So I said that last time, and it created a question, why so? And I agree that it's a question, but let's come back to that. Let's assume that the UN has adopted a decision and a state goes further than this decision, but on the basis of the same argument, of the same analysis of the situation. So basically the UN says state X has violated international law, so there should be some reaction. And then another state goes further and say, oh, well, yes, state X has violated international law, I will take further actions. Now, what I say is that in this case, the state adopting unilateral measures will be easy in demonstrating that state X has violated international law. So there will be a sort of presumption, quite a strong presumption, not irrefutable presumption, because the Security Council does not say the law. Security Council qualifies situations, but it could be a presumption. There will be a presumption, indeed, that the facts on which the claim that state X has violated international law are true, are correct. It's not a pretext, it is true. And so this is why I say that if a state adopts further measures against the state and claim that these further measures are countermeasures, for example, well, I mean, it will be quite easy for the state to defend its case, that this is indeed a countermeasure. When it comes to third-party measures, I think that the same reasoning works. So we know that the third-party measures are not stabilized in terms of legal regime, but let's assume that there is a legal regime for the third-party measures, which looks like a growing concern in the international community. Well, the third-party measures adopted against a state which is demonstrably acting wrongfully will be more easy to justify than if there were not such a UN decision before. So that's my point about the further sanctions. Now, let's take a look at another hypothesis, which is in the same group of questions. The hypothesis when the UN could not decide. So there is no decision at all. Not even a decision limited in scope and then the state goes further. No, there is no decision at all. And this is the interesting question of the veto exercise in the UN Security Council, blocking a decision which would have been unanimous if the veto had not been actioned. So this is the hypothesis. A vast majority of the UN Security Council supports a project of resolution inflicting a sanction, but there is a veto blocking everything. So you have examples of that. You have examples of a resolution against Syria that could not be adopted because of the veto of Russia, sometimes abstention of China. You have resolutions, of course, proposed against Russia in the Ukrainian situation, and of course, Russia blocked everything. And so the question is, are the unilateral measures adopted in such situation benefiting from a special regime? Because they replace a sanction that should have been taken by the UN Security Council if a veto had not been opposed. Okay, so that's a question that is put in the doctrine. Some authors plead in favor of that, and they say that, well, if we cannot overcome the veto, we should permit indeed the adoption of alternative measures than those that the Security Council should have adopted. My analysis is more classical. I'm more a classical lawyer, and I think that the law is the law, and that's a non-decision of the Security Council, because we talk about a non-decision, cannot have the same effect as a decision. So you cannot argue that, well, it is as if there had been a decision of the Security Council. Today, the veto right does exist. You can complain about that. You can say it's used in bad faith. It should be replaced by something different. But for the moment, it's not the case. And so my analysis is that an almost decision of the Security Council is simply not a decision at all. And so it cannot be the basis for justifying as such unilateral measures that would be taken in the alternative of the UN non-decision. Moreover, it is not solving the problem completely, but moreover, in case of a veto at the Security Council, and we said that 2 days ago, it's always possible for the UN General Assembly to take the situation in hands. Under Resolution 3775, the famous resolution at Ashison, the UN General Assembly can do what the UN Security Council does not. And it happened already. So that's something that you don't read in the textbooks because perhaps it's a rare case, but it did happen. With resolution, I give you the reference. It's an interesting point. Resolution ES91, adopted on 5 February 1982, so it's an old resolution, on the situation in the occupied Arab territories. So it was always the same problem with Palestine and the Israel's behavior vis-à-vis the occupied territories. And then at this time, the Security Council was supposed to adopt restrictive measures against Israel because Israel had behaved incorrectly. There has been a veto at the Security Council, and the Security Council was upset of the veto, so they asked to the General Assembly to take the subject. which is also a practice which is codified in the UN. It is possible even for the Security Council at a majority, and the veto does not work in this case, for the Security Council to decide to refer a point to the UN General Assembly. So they did so in this case, and the General Assembly adopted a resolution calling upon states to apply sanctions against Israel. So, of course, the General Assembly only called upon states to adopt sanctions against Israel. It did not decide because, you know, the recommendation of the General Assembly are not compulsory. But this calling upon probably could help the states adopting unilateral measures to justify their measures if they would run contrary to treaties or to other international obligations. Perhaps we can discuss later whether a recommendation of the UN General Assembly could fit with Article 21 of the GATT. And it will be a question I'm sure we can discuss later. Is it possible to activate Article 21 of the GATT as an exception to the obligation of the GATT, basing oneself on the recommendation of the UN General Assembly, asking
as an exception?
That tricky questions, but I think that's the more interesting questions. My analysis here is to say that a non-decision of the UN Security Council is a non-decision of the Security Council, full stop. And that means what? That means that if states adopt unilateral measures in lieu et place of the Security Council, they will have to justify their case. Now, perhaps, and this is something I do think, perhaps when they will have to justify their action, it will be possible for them to rely on the general view expressed at the Security Council that the action of the target state is wrong. So it will help, you know, to demonstrate the legitimacy of the action. But again, legitimacy does not mean legality. Now, let me turn to the last part of my articulation point, and then we will discuss a little bit more generally the lawfulness of unilateral restrictive measures, which is the hypothesis where you will have a unilateral measure contra a UN Security Council resolution. So perhaps it's difficult to conceptualize, but it's easy if you think of it. Imagine the UN Security Council, for any reason, adopting a decision sanctioning a state, Israel. And then imagine another state upset with this decision. So you will say, no, it's not possible because the state which would be upset with this decision would be the United States of America, and the United States of America would have opposed a veto to the initial decision of the Security Council, what they do every time. But you can have this sort of situation in case a resolution is adopted by an administration, and then you have a change of the administration. And this is something which is not unbelievable, as you saw. Everything that Obama did has been reversed by Trump. And so you can imagine that that's an hypothesis. You can imagine the United States accepting a resolution at one point and refusing the resolution later on. But it's too late, normally. So what would they do? Perhaps they would decide unilateral sanctions against those states implementing the UN sanction, right? So that would be, that's not something impossible. I repeat, let's assume that the UN Security Council adopts a resolution imposing a sanction, economic sanctions on the state. Let's assume that another state does not agree with this regime and says, well, I think this regime is insane. And so everybody which will implement this regime will be sanctioned by me. So that's the idea of a unilateral measure contra a UN Security Council sanction. That's the idea. So what would be the analysis in this case? Well, of course, when the Security Council decides something, it's the law. And Article 103 obliges states to respect what the Security Council said. So the states adopting sanctions against a sanction of the adopting a unilateral measure against a sanction of the UN Security Council would violate international law. Obviously, would violate the Charter of the UN, the Charter of the UN. So this sanction would be obviously unlawful. So have we got a case, a real case? We have Resolution 2231 of 2015, lifting the sanctions against the Iranian state. And so that's a recent resolution adopted in 2015. And this resolution so lifts the sanctions against Iran. And as you know, the United States reintroduced sanctions against Iran despite this resolution. And so some people say that the United States move is violating the UN regime. And the United States says no, because the UN regime does not create any obligation. So there is nothing compulsory in Resolution 2231. And then there cannot be any contradiction between the action of the United States and this resolution. So that's a debate, that's an ongoing debate. It's a complicated one, but that shows that this sort of hypothesis is not completely insane. So you see the articulation of the unilateral measures and the United Nations sanctions is quite a passionating subject matter. But at the end of the day, it calls us to have a more global reflection on, are unilateral measures that we call in the common language economic sanctions adopted by states against other states, are these measures lawful or not? 2 days ago, a question was put as to whether these measures are efficient, effective, if we should accept them, etc. Here, the question is, are they lawful? And as I said earlier, when I talked about the sanctions against the ICC decided by the United States, when you put the question of the lawfulness of something, you have to look at the rules. And when it comes to the rules of international law, we know that the main sources of the rules are treaties and customary international law. So let's look at the treaties. Are there treaties, conventions, prohibiting unilateral economic measures, inflicting damages to other states? Well, probably there are treaties creating the obligation to leave the commerce going on, to respect a sort of free trade obligations, etc. There are many treaties in this respect. But all these treaties, as far as I know, and there is one exception as far as I know, but nearly all these treaties contain an exception or several exceptions. And it is arguable that the unilateral restrictive measures are covered by these exceptions. So there is a case recently, which is well known, of course. It's the case Russia goods in transit. So I think it's the name. It's the case which has opposed Ukraine to Russia before the dispute settlement body of the WTO. And basically, Russia had sanctioned Ukraine, but adopted unilateral measures, so you know the terms, adopted unilateral measures against Ukraine by blocking the transit of goods from Ukraine on the territory of Russia, claiming that these measures were covered by Article 21 of the GATT, which says that nothing precludes a state from adopting measures which it considers necessary for the protection of its essential security interests in case of emergency in international relations or in case of in state of war. And so Russia argued that its economic measures against Ukraine were covered by this exception, and it worked. The dispute settlement body accepted the Russian argument that the exception was covering the situation. So when it comes to treaties, commercial treaties, including investment treaties, you will nearly always find an exception that could fit, and that in many cases will fit with the capacity of states to adopt economic measures against each other, embargoes, freezing of assets, etc. As I said, there is an exception, which is very bizarre. There is a treaty between the European Union and Peru and Colombia. I think it's this one. And I didn't see, it's a treaty of commerce and investment. I didn't see the exception. So the classical exception you find anywhere, derived from Article 21 of the GATT, is forgotten from this treaty, as far as I know. So when it comes to treaty, all depends on the treaty, of course, and you have to have a treaty assessment, but in many cases you have exceptions. And you know, there is a case before the ICJ on this very question, which is the case between Iran and the United States, which is putting the question of how far the exception contained in the Treaty of 1955 with Iran covers the actions of the United States. It's a little bit different, but that's close. Now, if you put apart the treaties to assess whether a unilateral measure is lawful or not, you will look at the customary international law. And so, can we find rules in customary international law that oppose the behavior of a state inflicting damages to another state for any reason? So you have several rules that could be called upon. You can call upon the rule of non-interference. So that's a classical concept, a classical chapter in the law books, non-interference, the principle of non-interference. Now the question is what it means exactly. And if you look at the practice, and if you look at the case law, it seems like the only interference which is contrary to customary international law is the one which is based on the use of force, constraint. So if you have an interference which is not based on the use of force, it's more complicated to demonstrate that it's unlawful. So in order to prove that, you can take a look at the decision of the court, the International Court of Justice in Nicaragua versus the United States, the decision of 1986. And the court seems to say, in this case, that interference is unlawful in international law if it is basing itself on constraint, an act of constraint. And in the idea of the court, it looks like constraint means use of force. So that limits, of course, the possibility to rely on non-interference to contest economic measures like an embargo or things like that. Now, there are treaties that go a little bit further when it comes to non-interference, but here we come again to treaty law. You may know that Article 19 of the Charter of the Organization of American States, Article 19 of the Charter of the OAS, says as follows: no state or group of states has the right to intervene directly or indirectly for any reason whatever in the internal or external affairs of any other state. The foregoing principle prohibits not only armed force, but also any other form of interference or attempted threat against the personality of the state or against its political, economic, and cultural elements. But that's a treaty. That's not customary international law, and it's a treaty limited to the members of the Organization of American States. So that non-interference in general seems a little bit limited in its effects on this question. Now we have perhaps another argument that should be assessed, which is the arguments of abuse of rights. That's perhaps a way forward for a better analysis of the unilateral economic measures adopted by states against other states, the notion of abuse of rights. Indeed, when a state adopts measures against another state, in fact, it is implementing its own sovereignty. It is saying, well, when I decide an embargo, I am acting as a sovereign on my territory and vis-a-vis my people. And this is exactly that. An embargo is a measure by which a state says in a law to its people on its territory, you will not buy or you will not sell products with or from this country. And so a state implementing such measures says, I'm sovereign, I'm acting like a sovereign on my territory. Now the question is there a limit to what a sovereign can do on its own territory? And the answer is yes. In international law, we know since a long time that a state cannot use its territory to cause a damage to another territory. That's the basis of the reflection. And then we could perhaps think that the theory of abuse of rights could apply to the sovereign rights of states on its own territory, and when this sovereignty is used to cause a damage to another state. So I know that the theory of abuse of rights is a bit. So to be honest, when you plead before a court, there is always someone coming with, oh, should we plead abuse of rights? And the other lawyers, they say, yeah, that's a losing argument. That's the argument you put forward when you have nothing to say. So the theory of abuse of rights is a bit limited in its efficiency in international law. That's true, but it does exist. And I refer to the case concerning certain German interest in Polish Upper Silesia of 1926, in which the PCIG recognized the reality of this theory in international, its positivity in international law, and also the case of the free zones of Upper Savoie and the district of Gex of 1932. And more recently, the ICJ in a case involving France and Equatorial Guinea seemed to accept the notion that abuse of rights can be argued before itself. So there is perhaps to develop, in order to better understand what is the legal regime of these measures adopted by a state against other states, perhaps there is a way forward in thinking under the headline of abuse of rights. What are the limits of what a state can do on its own territory and vis-a-vis its own people in terms of abuse of rights? One of the abuse of rights could be, in my view, it's the more straightforward opening of this theory is when a state will sanction, I say sanction in terms of domestic law, will sanction the activities of a foreigner for things it done vis-à-vis a foreign state by using its sovereignty and applying sanctions to this person on its own soil. So that's the famous extraterritorial sanctions, in fact. So it's not very clear the manner I presented it, but it's about the so-called secondary sanctions or extraterritorial sanctions. How does it work? Well, for the moment, the extraterritorial sanctions are mainly coming from the United States and perhaps exclusively coming from the United States. So I'm sorry to insist with the United States, but that's a fact. And the United States say to me, a French person living in France, well, if you do something with Cuba, I, the United States, will sanction you on my territory. And so there is a territorial link, a territorial nexus argued by the United States. He said, well, I'm acting against Jean-Marc Thouvenin only to the extent that Jean-Marc Thouvenin comes to my territory or has assets located in my territory. So I'm sovereign, I'm implementing my territorial sovereignty. But I think that here it is arguable that we are confronted to an abuse of sovereignty because the very reason for the implementation of this sovereignty to me is interference, is trying to force a foreign state, France, to follow a foreign policy which is not the one France has chosen. So this is something to be developed. For the moment, it's too early in time to succeed in bringing such an argument, perhaps before a court, I don't know. But I think that the doctrine could think of what are the limits of the sovereignty in terms of abuse of rights, in particular when it comes to think of the extraterritorial sanctions. So that's an opening on which I wanted to follow this initial discussion. Perhaps I have to finish also on another point. I talked about customary international law that could contain elements against which assessing unilateral measures. And I talked about sovereignty, abuse of rights. Sometimes, in some cases, probably immunities can also be of help. And so in this regard, I would just like to call your attention on the fact that more and more states, not only the United States in this case, adopt unilateral measures against other states, including the freezing of the assets of their central banks. The freezing of the assets of the central banks. And so, the assets of the central bank are immune in international law. They are mentioned expressly in the convention, the United Nations Convention on Immunity of States and their property. And the property of central banks are immune from execution. And so the unilateral measures that lead to confiscate the assets of a central bank can be assessed probably against the theory of immunity from execution. So that's perhaps the last path, the last idea I wanted to share with you. I'm afraid I'm now up to my 60 minutes, and perhaps you would like to have some discussion. So I don't have sound.
No, okay. Now it's okay?
Yes.
I'm sorry, I'm having some problems here with my computer and so on. So sorry. Okay, thank you very much, Professor. It was a very...
I can listen to you.
No?
Yeah, it's okay.
It's okay now? Okay.
Yes.
I have to change here something. Okay, let's move on to the questions. I think it would be interesting. Thank you very much for presentation. It was very interesting. I have many questions of myself here, mainly because it involves WTO and GATT and those measures that are implemented by the system of resolution of dispute settlement resolution of the WTO. But this is not the case now to have this approach with you here. So I think it would be more interesting to face the questions of the students, if you don't mind. Can we go there? Okay. Okay, Professor. People are asking here something. Let me check. One moment, please. There is a mix of questions here. Okay. First of all, we have Giovanna. Giovanna is asking here. I missed the reason why the United Nations was highly criticized in the 90s. Can someone help me out? Could you please repeat the beginning of your presentation for her, if you don't mind?
The economic sanctions have been considered an easy way to avoid war after the Second World War, in fact, and even during the Second World War. Wilson said that a people which is starved by economic sanctions will surrender far more easily than if it is under the threat of arms. And then the United Nations followed this idea at the beginning of its, at the beginning of this after Glasnost period. In the 90s, the United Nations adopted classical sanctions against, in particular, Iraq. And so the United Nations put in place in the 90s a very comprehensive embargo against Iraq. Because Iraq had behaved badly by invading Kuwait, so you know the story. And so it was very harsh. Even the people going to school, I mean, the young people going to school could not have pen or paper. People had difficulties in finding food. And so all the people were starved. And by contrast, Saddam Hussein was going very well. This is what was said. And the government was going very well. And it was said that it was hiding arms, that it was developing a program of chemical weapons. So the sanction was at the same time inefficient and hitting the innocent people, women, children, and men, of course. And so it was so strong that perhaps you recall that the United Nations put in place a regime of oil for food, which is incredible. And so it was so incredible that it worked very badly. And there has been a lot of corruption around the program of oil for food. But the oil for food program was a first tentative of the UN to respond to the critics, which were saying, you are starving people, you are not doing things right. And so oil for food was a disaster. And then after that, the UN understood that it could not go on any longer with these general sanctions. And it decided to put in place regimes of smart sanctions. So that these are the sanctions that are targeting directly those who are supposed to be the wrongdoers. I hope it's clear.
sorry. It's okay now?
Yeah.
Okay, I'm so sorry. I have to change this equipment here. Okay. Oh, all right. Can we move on?
Yeah.
Okay, thank you very much. This is a very important explanation that I used to talk about with my students in the classroom. But okay, now we have here Thais Almeida. He's asking, Professor, good afternoon. I would like to ask if you believe that the United Nations Security Council referrals to the International Criminal Court can be considered as a new form of sanction.
I don't think so.
No.
I don't see the link. I think that suing someone because this someone could have, because before being guilty, the person is innocent, but because these people arguably has violated international criminal law, I don't see that as a sanction. Not at all. Perhaps I should define what is the notion of sanction in international law. A sanction, and I think I had brought this definition at the beginning of my speech, but a sanction, a UN sanction, is a measure aimed at creating a damage to a target, and generally it's an economic damage, in order to obtain from this target a change of behavior. That's basically a sanction. A sanction is a measure inflicting a damage to a target in order to obtain from this target a change of behavior. So the referral to the ICC is obviously something different.
Yes, okay. All right. Now we have here Giovanna Thais. Just a moment, please. Let me check here. Fernando Porto is asking you, Professor, in your view, is the criterion of equivalent protection adopted in the CADI and NADA cases sufficiently satisfied by the non-judicial review mechanisms such as the United Nations Security Council ombudsperson?
No, absolutely no. I think it's absolutely not sufficient. When it comes to the right to defense, the defense is supposed to be available before a judge. And the judge is responding to a certain definition. The ombudsperson is not a judge. It has no authority to decide, finally. And the last to decide is the Security Council itself. So that's not sufficient at all. I think also, it's not I think, but I know that the European Court of Justice said so, because there has been a CADI 2 case. And in the CADI 2 case, it was said that it was absolutely not sufficient. But I think that at this moment, the Security Council seems to be happy, accepting, if you prefer, that local courts could perhaps oppose to its measures or modify them or ensure the right of defense as they should be. So the Security Council seems to say, well, the system is not perfect, but let's work on this basis, because the Security Council does not want a judge to take decisions compulsory for it. So that's not satisfactory, but that's the situation today.
Okay. And then we have here Fernando Porto. He's asking, Professor, if a state adopts a unilateral sanction against another state implementing the United States Security Council sanctions, can a third state adopt measures against the first one?
A state adopts a measure in implementation of the UN sanction.
Yes.
And then the third one says to the state, oh no, you should not. And I adopt sanctions against you. That's it. Okay, no, but that's the hypothesis I mentioned in my third party, I think.
Yes, I think so.
Yes, and I said that normally no, because you should respect the decision of the Security Council, and you should respect Article 103.
Yes, but maybe if it is a unilateral measure, economic measure, the state can force the other to implement the measure.
Oh, yes. So that's the idea of extraterritorial...
United Nations.
Yeah, so I understand. So the hypothesis is there is a UN sanction, but not all states implement it. So it's inefficient because of that. And indeed, if an economic sanction is not implemented through the world, it's not efficient. It's sufficient to go to China or to I don't know where, and then you will escape the sanction. So that's indeed a concern. And the United States indeed tries to force the other states to implement the UN sanction. That happens in the North Korea case.
Yes.
Is it allowed? I think I addressed this point 2 days ago when I said that a state is not allowed, is not called upon at least by the UN sanctions to implement the sanction in an extraterritorial manner. So it's not covered. So these measures having an extraterritorial reach will have to be assessed under the normal rules of international law.
Okay.
It will not be covered, not be immune thanks to the UN sanction that it is supposed to implement. It will not. It will go further, but further in such a manner as it should be assessed as to its legality according to the normal rules of international. And this is why also I mentioned the other rules of international law, customary international law, treaties. It's against these elements that the legality of the measure should be assessed. Okay,
thank you. The next question here is from Rodrigo. Professor, do you believe that sanctions adopted by the United Nations enjoy more legitimacy in the international society? Because unilateral measures are often seen as results of political interests and interference.
Yes. When it comes to the legitimacy, of course, the assessment is political.
It's a matter of diplomacy.
Yes. When it comes to the UN sanctions, they are legitimate as such because the UN has the power and has been remitted the power to adopt these sanctions, Article 41 and 42 of the UN Charter, and because the United Nations is supposed to represent the international community. So there is by definition, the UN is legitimate and is perhaps the only legitimate to adopt sanctions against states. But of course, you will have also situations where unilateral sanctions will be presented by their offers as legitimate. Look, listen to Pompeo explaining why he adopts sanctions against Venezuela, Cuba, etc. For Pompeo, it's very legitimate. And Pompeo does not understand why the whole world is not following the United States position. And so I think that the debate on legitimacy is a bit flawed. And this is why I said from the beginning, when a state can connect its sanctions, even autonomous, to a UN position, it helps him to pretend, to contend that this measure is legitimate. Does not mean that it's lawful, but it helps to say that it's legitimate. Because if you don't have this connection with the UN, everything is legitimate or not legitimate. Listen to the Chinese positions, to the Cuban positions. That's all political tensions.
Okay. Yes. And now we have here Fernando Porto. He's also asking, Professor, if a state adopts a unilateral sanction against another state implementing the United Nations sanctions, you have already asked this one. I'm sorry. Augusto, Professor, is the argument of states going further than what it was decided by the Security Council something easy to defend only when it comes to economic sanctions?
So the question is, what other sanctions have we got in the international relations than economic? What else? You have not a lot. You have perhaps cultural. I don't think so. You have what other sanctions have you got? You have prohibition of transit of people on your soil, refusal of visas, expulsion of diplomats. All this, by way of definition, is not incompatible with international law. It's in the realm of what a sovereign can do. And so there is not even a question as to the legality of these measures. The only question as to the legality of the measures touches upon recourse to economic measures because the world is replete of international economic obligations. And so I don't see really the hypothesis here.
Yes, but don't you think, Professor, that sometimes the economic sanction can be something that can go wrong instead of go to the target of the objective of that sanction? Maybe the case of Syria, the Lockerbie case. The Lockerbie case was something that in the end they make the regime of Gaddafi more stronger than before, and then it was prejudicial for the people, the Syrians.
Yeah, but the Libyans, the Libyans.
The Libyans. I'm so sorry. Yeah.
The Lockerbie case was about hijacking and terrorism.
Yes.
And so I think that the case was concerning a narrow point. Who can judge these people? And did it reinforce Gaddafi? Perhaps, I don't know. At least what happened next, the judgment of these people in Scotland, cleared Gaddafi. That's the point. So it was. I'm not sure it was a bad thing. I think that the case was quite successful because at the end of the day, the people indicted were judged, were prosecuted in Scotland.
Yes.
And one have been relaxed, the other has been condemned. So it was a good justice. Okay. So I think that at the end of the day, the Lockerbie case at large ended up very successfully.
Okay.
As such, yeah. And the objective of the Lockerbie case was not to obtain the head of Gaddafi at all. I don't think so.
Okay.
But to answer your point, are sometimes economic sanctions, economic measures doing more wrong than right? Is it with imagining that helpful? I do think so. As we said 2 days ago, I come from a period of time where diplomacy was supposed to be the solution. It would not,
Sometimes it's better the diplomacy than the sanctions, the economic sanctions, the economic measures, I mean.
Look at the sanctions against Russia after Crimea.
Okay.
I think that the Europeans and the Americans, they could not do anything different because the violation of international was gross. But did it help in any way? For the moment, no. So who can think that the little economic measures adopted against the gym professor of Putin or such member of parliament will change the path of Russia in the Crimean case? Never it will work. So in this case, I think that economic sanctions were absolutely not the solution. Perhaps exclusion from the UN or perhaps other sort of sanctions should have been taken against Russia. A complete isolation in terms of economic relations, something very strong. But it was not possible, and it could have been also counterproductive, because at the same time, you know, the problem of the Europeans, they say we don't want to isolate Russia, because if we do, Russia will turn to China and they will create a new power. So that's all politics. But finally, if you look at the sanctions against Russia, it leads to nowhere.
Yes, we are facing now the end of the WTO. We are facing the end of the multilateral system of WTO, and also the problem of the single undertaking, because WTO, it was had credibility, has credibility, or had credibility because of the single undertaking and the capacity to of the system of a dispute settlement system works. And now we are facing that situation very peculiar, and all that treaties are not so efficient as before. Don't you think that because of the WTO is always working over an economic sanction or something related to measures related to economic, and so when the state decides not to follow it doesn't follow. So we have this problem here for the international law. International economic law is changing a lot.
I think that the WTO is victim of a political move, but is also victim of a certain naivety. It has been a bit naive, in particular vis-à-vis China. Well, the sanctioning system of the WTO is not very efficient. It's obvious, in particular because the small states who would win a case against big states would not be able to obtain justice by themselves. They cannot sanction the big state in order for obtaining that the big state respect its commitments. However, as far as I know, and perhaps the European Union is an exception, but states do respect the decision of the WTO. This is what I heard. So they don't need sanctions, in fact. Save the European Union again, in the case of the beef with hormones and in particular this case, and the banana case as well. But in general, they do respect. Nowadays, the WTO is victim indeed of an attack from the United States. But I was in the American Society of International Congress 2 years ago, and I heard someone from the Department of State explaining why they had a problem with the WTO. And it was very clear. He said, when we entered into the WTO, we thought it would be a vehicle for us to gain markets abroad. And we thought that the judges, the dispute settlement body, would help us. This is what we thought. And now we discover that we lose cases, that everybody wins cases against us. We are the bad guys. So the system is wrong. We will throw it out. So that's the position of the UN. The United States thinks that the WTO should be helping them, and not disciplining them. And that's the political position. America first. I think that's the reason why the WTO is a victim. It's not a question of how the WTO works. I think it did a good job. No, I think it's because it did a good job that it is in peril now.
Yes, that's it. I agree with you. Okay, Professor, thank you very much. I'm so sorry about my gadgets here. I have this problem of gadgets and I lost a little bit of my attention. I'm sorry again. And I hope to see you here in Brazil very soon. And thank you. It was a great pleasure to moderate this lecture with you.
Thank you very much for having me, and thanks to the students for the questions. I'm sorry if I did not respond to all the questions, but I suppose there were a lot. And I really hope to see everybody in The Hague or in Brazil very soon.
Yes, I hope so.
Thank you.
Thank you. Bye-bye.
Thank you. Bye-bye.
Bye.
Bye.